Now, that's another question that is worth discussing. Why there is this shift, and largely authorized shift of political power from parliamentary sovereignty, which is a dogma only in the United Kingdom, to a sort of divided power between elected and non-elected organs. So I think that I could go on forever, but I will stop here because, as I told you, this is not at all a conclusion. It is evident, and we have time to continue a little bit our conversation. I would create a connection between these contemporary debates and history. Michel Troper, in an old paper, makes a useful distinction, a semantic distinction, claiming that the word constitutionalism, which in itself means nothing, may be defined in three different ways. That's my language now, not Michel's language. So there is the Aristotelian concept, according to which any political system has a constitution, a tyranny, a mixed government, an aristocracy, blah, blah, blah. So constitution and constitutionalism is the analysis of political forms. He said that that's lato sensu. The stricto sensu, and that's important for me, is the Sieyès definition of constitutionalism, which is summarized in the Article 16 of the French Declaration of Human Rights, where it's said that there is a constitution only if, so according to the French Revolution, there is society without constitution. It's a clearly anti-Aristotelian point of view. There is a constitution if and only if there is separation of power and guarantee of rights. This is the beginning of the modern concept of constitutionalism, but Michel says there is a third definition of constitutionalism, strictissimo sensu, where, that's again my language, the guarantee of rights is taken seriously. And there is an agency in charge of guaranteeing these rights. So in that sense, there is a connection between, that could be a connection between the old and the new constitutionalism. The fact that in the modern world, starting with the 18th century, rights entered strongly in the picture, which was not at all the case for the ancient tradition. I mean, not because they had no rights, but I mean, constitution had nothing to do with the idea of rights, had to do with the political form. Okay? So the politeia is the structure of the political system. Now, with the French Revolution and the American Constitution, rights become part of the political system, and the guarantee of rights has to be realized or achieved by someone. And the general answer in the contemporary world went in the direction of Kelsen and not in the direction of Carl Schmitt, meaning in the direction of the United States and Germany and not in the direction of China. Because in China, if you come to the seminar I organized about the Chinese control of hierarchy of norms, you will see that in China, controls of norms, including rights, is made by political actors. That's the Schmittian model. It's in fact the model of the French Revolution with the référé législatif and so on. No? That vaguely is the same idea. I mean, if there is a problem concerning the interpretation of law, what you do? You send the question to the parliament. Well, that's exactly what happens today in China. There is a functioning mechanism of référé législatif. But that's the exception. The rule is that in general you send this question to judges, which in very different forms, because I agree with Jean-Louis. I mean, this is a general trend, this judicial review, but the morphology is extremely differentiated, and the interest of having you here is because we are interested in these differences. The general idea that there is, that's we know that there is, but what we don't know is the differences. And so thank you for helping us to understand this variety of forms of judicial review. But that's just my small contribution. You come back and make remarks and whatever you want.
Actually, I had a question towards it, because I know that one of the major issues, you mentioned the different reasons why there was constitutional review, for instance, because of federalization or post-authoritarian regimes and so forth. But in the Netherlands, it seems like it's mainly with the influence of Europe, and especially with violations being established by the European Court of Human Rights, that they kind of want something on the national level, and national judges also take the Constitution into account. And I wonder to what extent that has kind of, if that is a major issue in the Scandinavian countries, or if it's based on other issues.
But at present it is a major issue, but it was not a major issue when it all started in the 90s.
Yes, of course.
I mean, then it was basically mentioning, you were talking about the administrative decisions, and initially there was expected to be review of administrative decisions. This was actually contained in the first Danish constitution and the Icelandic. I don't know about the Norwegian. The special role of the courts to review the competence of the administrative authorities. Initially, this is presumably aimed at some kind of arbitrary decision of the authorities, and we had all the principles developed there, like, I mean, the principle of proportionality, for example, which is a very important principle in administrative law, and a very well coming from Germany, I guess. And these principles started developing in the review of the administrative decision. But when it comes to the question why it starts developing with respect to law in Scandinavia, Iceland at that time was under the Supreme Court of Denmark, I mean until 1920 basically. So what the Supreme Court of Denmark said had effect in Iceland. There wasn't any big political debate about this role in Iceland, actually. Not what you can see from Norway when you were comparing those who are, I mean, the property rights and so on. I mean, the right politicians were supporting the property rights, whereas the socialists were not. So I think that Iceland adopted this particular development through the Danish connection. And in Denmark, they started looking into this, mainly in relation to some kind of limitations of employment freedom. I mean, those who wanted, well, which is very connected to the property rights, because those who had all kinds of licenses, according to the law, there will maybe new law which limited their operation in employment. So they felt that this was like limiting the property rights, and they lost it. That there were financial damages and so on. This is where the initial cases coming from Denmark, at least, which have bearing for Iceland, are coming into these. The judicial review is developing, and it's not taking any big political debate. Not at that time in Iceland, but it's maybe not the same story in Norway. What happens later on, I mean, judicial review is not really there are not many in Iceland saying that the court do not have the power to do this, because it is there and it is acknowledged. The main debate in Iceland is now extending to what I explained here before, which types of rights, because we had judgments on the right to social support, for example, like I mentioned. And then there was the question about how is a person entitled to social benefits and how high should they be, and why in the world are the courts involved in decisions of social and economic rights like this. But this is what has been developing, and this is the main debate in Iceland, I guess, now. To what extent would the court stretch the judicial review of human rights, which is just generally acknowledged, into issues which by many, especially people in the most right parties, would be saying that the court should not be discussing or deciding upon social rights. That's only for the government to decide. That's the main debate we are absolutely experiencing in Iceland at the moment. And the initial development is, at least from the point of Iceland, from the viewpoint of Iceland, there was not any difficult political debate we went through, but probably because we adopted it. It was, already prepared beforehand, but there was a different story to say from Norway, maybe.
Well, you can, of course, if you are looking at the traditional historical explanation of judicial review, which then is seen as a response to Oscar Howe's proposals then in the 1870s. The traditional explanation is that it was a reaction against parliamentarism, and then you created, if you like, an independent agency then in the courts reviewing legislation, which then replaced the king, who could refuse, or the executive, which then could refuse sanctioning legislation. So that's one perspective. And in a way that fits in with the totalitarianist perspective as well, doesn't it? So somehow it's political change, and you use this either to achieve or to control political change. So somehow it is triggered by some kind of political change, revolutionary or fundamental change. When it comes to the new property and retroactivity cases of the 1970s, they were not triggered by any such change, because perhaps it was well, I'm not absolutely certain, but it was clearly, the Supreme Court was clearly divided. So all the Social Democrats in the then Supreme Court and the centrists voted with the legislature, and it was the Conservatives, the people who actually would vote for the Conservative Party or belong there, although they're not supposed to be open about this in the Norwegian context. It was a clear political division in the middle. But the more recent developments are clearly triggered by the European Convention and, of course, to some extent also European Union law. So that the judges would then start to review domestic legislation based on particularly the European Convention, and they would become quite confident in weighing and balancing and applying a proportionality review, and then they take that further into the domestic review. So I think in terms of court review of legislation on the basis of domestic constitution, that clearly has been triggered, in my view, by the impact on the court's parallel case law, its parallel jurisprudence on the European Convention. But then, of course, you have also, we talked about all these ways of separating and trying to distinguish and trying to establish independent basis for review. There are many other factors in there, but you asked about had Europeanization had any impact on what the court or the more intense review?
If it's
yes.
Because what I've read is always it's quite differential and things like that, and I wondered if that had changed the attitude.
In the Norwegian context, it's clearly changed because it's two things. First of all, one's no longer having a mirror principle. It is clear that one goes beyond, one is the convention and one goes beyond, and then one has developed grounds of review on the basis, more actively using the domestic constitutional grounds, and one has then in addition applied these principles, which are very vague as of now, perhaps very situational, but it's clear that this has a causal, it's very difficult to explain away the causal relationship there.
I have some questions actually for you and for Pasquale too. For you both, because I was wondering, but I'm not sure I'm right. I was wondering whether you had some kind of rights that are quite specific to your regions, namely the rights on the soil, on the natural resources. You know, these kind of new rights that are, especially in the new Icelandic constitutional process. And I think this brings something new, but I was wondering about this. Do these kind of rights have an impact? Do you think so on the way judicial review could develop, or is there a connection between these kind of rights, this kind of third generation rights, and the second generation rights, like the socio-economic rights, as I said, where judicial review is not supposed to exist? I'm wondering.
Yes, I think it's a really a valid question. It's the core of the discussion we have in Iceland now. Just to say it briefly. I mean, especially, I think we should maybe distinguish. We have this, if we have this traditional civil and political rights, economic and social rights. Mm-hmm. In principle, they've been focusing on the individual, nevertheless. Mm-hmm. I mean, the problem is whether an individual can rely on the right to social benefit or something like that. But now we are adding, and in our new revision, the new draft we are dealing with now in Iceland, which I am not very happy about, and because probably I'm conservative or something like that. We are adding all these rights specifically aimed at the nation, the property of the nation. The natural resources are owned by the nation. And they should, you have something similar in your, but ours is much more detailed. And it's contained in the human rights chapter, which means that what they basically do is that they are restrictions on the property right. Exactly. So they are basically aimed at restricting individual rights. Yes. And that's what I've been trying now in the debate in Iceland. And I'm trying to say, please try to distinguish between what you want to have an enforceable individual rights and the group rights. And then there are there's the right of animals, for example, to enjoy protection. And there's the right of people to enjoy beautiful nature and all these symbolic things. I've been trying to preach, if I could say, that when we start developing all this symbolic meaning of the Constitution, when we move away from the concrete principles which can be applied in individual concrete cases, the problem is it's a bit watering, down the what you say. It will not be as efficient, in my view. I think it's jeopardizing the Constitution as being quite an efficient basis in individual cases. But I mean, I think the Icelandic constitution base is in a way a bit different from the Norwegian and the Danish in that respect, because since 1995 there have been unbelievable developments in principle of equality, for example. I mean, so many new unforeseeable cases that we had, and the right on social assistance, which was unexpected judgments we got there in the benefit for people with benefits, disabled pension for disabled people. But now what worries me is that now we had this group of people who was working in the constitution, and they wanted to add everything into the human rights, and the rights of the nation are more and more coming in, especially with respect to natural resources. And this is one of the most difficult issue at present in Iceland. Everybody think, it should be there to some extent, like you have in Norway, for example, but it's so much detailed that there are quite many afraid that this may, to some extent, affect the property rights of those who are operating in the fisheries, in the energy business, and all that. I mean, these classical problems. So yes, that's a relevant question, and I think the development is taking us there. And it's difficult to foresee what will be the impact, but I'm trying to at least say a word of warning that we should not put everything which is ideal and well, the rights of the nations as such and these group rights, because in the long run I think it will mean that the other part will maybe be less efficient, and then we will just turn it back to the European Convention on Human Rights. Well, but they are stretching their field of application also there. But this is a very good, and I think the development in the next year will very much focus on how to deal with that new group of rights. Maybe this is something which will naturally, either at the end, in 100 years, this would be considered to be absolutely obvious thing to put all this in constitution. But well, we should be conservative at least to some extent, shouldn't we?
Second provocative question, which is a twofold question. First, it's kind of epistemological concern. Pasquale, what is the justification for choosing so-called northern European countries? And do you have a justification for including Britain? Second, and the Netherlands actually, and assuming that Scandinavian countries is a kind of entity or something, like a cultural thing or whatever. So I was wondering whether this was assumed or not with the gathering of these northern European countries. And second, if the criteria to put these countries together is the non-post-authoritarian state, then what about France? Why is it that France is not included in the northern countries? And where would you place this country?
Yeah, well, I can answer very quickly. For me, France is part of these non-post-authoritarian countries. It's not included because, I mean, you know everything about France, so we don't need. So, but seriously speaking, there are two common elements between the country we have been discussing plus France. There is one common element. The common element is the fact that these are countries which have no clear authoritarian past. And that is interesting because, as I told before, there is an idea, even Professor Habermas told me that judicial review is important for a country like Germany or Italy because these are not good people. But the good people in Scandinavia do not need it. No, that's what he claims, you know. So, and I think this is a wrong.
I agree with him.
No, but it's not true because this country have forms of so. And France is part of this war. France has nothing to do with Germany, you know, from this point of view. And it's a recent development because la saisie par mandat is not judicial review. I mean, it's the question préliminaire, which makes France part of this very recent non-post-authoritarian development. The other common point is that these guys, they speak languages we cannot read. You need them to learn something because, I mean, Germany, I have no problem. I don't need Germans, but Icelandic. It started when I went to Iceland and I met Björn. I said, why you don't have judicial review? And she said, what are you saying? You don't know everything. Why are you saying? So I said, well, I have to invite her because, yeah.
suis désolé, je vais parler en français. Je n'ai pas les compétences linguistiques pour m'exprimer en anglais, excusez-moi, sorry. J'étais très intéressé par les différentes perspectives proposées par Pasquale, en particulier la celle dont nous parlons actuellement. Et excusez-moi, parce que non seulement je ne vais pas parler anglais, mais je vais un peu m'attarder sur le cas de la France, parce que je trouve ça très intéressant. En effet, tu as à un moment donné parlé de la France comme étant un modèle qui aurait été d'ailleurs d'inspiration pour Kelsen par rapport au modèle américain. La contrôle constitutionnalité des lois aux États-Unis, c'est une affaire de fédéralisme. La France propose autre chose qui s'inspire de la justice administrative. Il y aurait l'instauration à un échelon supérieur de la même structure que celle qui vaut pour le contrôle de la légalité de l'acte administratif. Mais comme tu le dis, ce qu'il y a de très insolite dans ce modèle français, c'est que ça concerne un pays qui, non pas n'a pas eu de passé autoritaire, mais qui se perçoit lui-même comme n'ayant jamais eu de passé autoritaire, c'est-à-dire un pays qui s'estime être un modèle de démocratie depuis toujours, et qui par conséquent vit dans un univers normatif, une structure juridictionnelle assurant le contrôle de l'égalité, par exemple, grâce à une institution, le Conseil d'État, qui est instauré par précisément c'est précisément l'incarnation même du régime autoritaire qui pose ce à partir de quoi va se construire l'édifice, qui est un édifice en fait d'auto-contrôle. C'est l'administration qui se dote d'un organe qui se contrôle lui-même. Le droit administratif, c'est l'administration qui est juge et partie. Et il se trouve que la justice constitutionnelle en France, malgré la QPC, demeure exactement conforme à ce modèle, puisque le Conseil constitutionnel, c'est un organe qui n'est pas à proprement parler juridictionnel, mais qui contrôle un corps politique, le Parlement, mais dont les membres sont non pas élus, sont pas nommés comme des magistrats, mais sont désignés par les hommes politiques qui sont soumis à... Et donc, en gros, le Conseil constitutionnel, c'est à peu près pour la même chose que le Conseil d'État, et c'est d'ailleurs ce qui fait le malaise pour les constitutionnalistes français dans la comparaison avec les autres pays européens, et notamment avec le modèle allemand. Donc, incontestablement, il y a, je trouve, dans cette idée de faire de la France une sorte de point d'observation intéressant pour comprendre, ça me semble tout à fait exact, mais quelque chose qui devrait conduire les Français à probablement modifier l'analyse sur leur propre modèle et à précisément leur faire prendre conscience du fait que le fameux modèle désigné par Michel Trotter comme étant strictissimo sensu le modèle démocratique le plus abouti, c'est un modèle où justement la liaison avec le deuxième modèle, c'est-à-dire l'article 7 de la Déclaration des droits, où l'idée est qu'il faut qu'il y ait une garantie des droits, mais il faut aussi qu'il y ait une séparation des pouvoirs. Il faut que cette séparation des pouvoirs ait été jusqu'au bout de sa détermination, c'est-à-dire qu'effectivement l'organe qui contrôle le Parlement soit un organe